Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and non-practitioners galvanized by intensifying worldwide scrutiny of these fields to learning more. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Unfair Competition Committee of the Antitrust Law Section. Today's episode is on the utility or futility of pursuing RICO claims in private antitrust litigation. The Racketeer, Influence, and Corrupt Practices Act, or RICO, was passed in 1970 to enable the prosecution of organized crime families. Prior to that, while prosecutors could go after individual members of these crime families who broke the law, they had no real way of going after the bosses or the criminal enterprise itself. But despite its name and origin, RICO is not limited to mobsters or members of the mafia. RICO increases civil and criminal penalties when a person, in connection with a criminal enterprise, commits any of the 35-odd crimes that are enumerated within the statute, which does not include violations of the antitrust laws. Today, we're going to talk about how antitrust plaintiffs' attorneys tried using the RICO statute in follow-on litigation to two massive benchmark manipulation cases, LIBOR and broiler chickens. So what do we mean by benchmarking? Well, industry benchmarks are a reference point that allow companies to measure their performance against the industry as a whole. They're often created through surveys that go around to competitors in a given market and ask them for non-public information, which is then typically published anonymously and in aggregate. In the US, the exchange of competitively sensitive information between competitors can give rise to an antitrust violation. So let's start with LIBOR. At one time, they called it the most important number in the financial world. The London Interbank Offered Rate, or LIBOR, was an interest rate average that was calculated from estimates submitted by some of the leading banks in London. Each business day, these banks would submit to an association their estimate of what it would cost to borrow from other banks. And the association would then compute and publish the average of these submitted rates. LIBOR was the primary benchmark for short-term interest rates around the world. However, traders were rigging LIBOR to benefit trading positions that they had taken in advance, thereby defrauding counterparties who were unaware of the manipulation. The U.S. Department of Justice initially charged some 14 individuals and 10 of the largest banks in the world with allegedly illegally manipulating LIBOR. Most of the banks that entered into deferred prosecution agreements with the United States, and a number of the individuals were convicted, although some of those convictions have since been overturned. Now, in the follow-on plaintiff litigation brought by a bondholder under the Sherman and RICO Acts, Judge Paul Garbeth of the District Court of the Southern District of New York, in a holding subsequently affirmed by the Second Circuit, dismissed the plaintiff's RICO claim on the grounds that the plaintiffs had not demonstrated that the banks had been the proximate cause of its harm. The second benchmark case we're going to be talking about has to do with broiler chickens. And these are the chickens that are the most common type that end up on your plate. So these cases allege that in the late 2000s and early 2010s, broiler chicken producers were deliberately underproducing the number of broiler chickens on the market in order to drive up prices. And if you look at broiler chicken production at the time, there were unusual dips in production from an otherwise linear increase over that time period. Now, this kind of behavior wouldn't make sense for an individual producer to pursue because anyone who tried to unilaterally restrict their output in a well-functioning market would expect a competitor to jump in and meet any demand that the supply decrease might cause. In a private antitrust case, broiler chicken purchasers alleged that chicken producers had conspired to manipulate a wholesale chicken price index known as the Georgia DOC, which had the effect of decreasing supply and raising prices. Judge Thomas Durkin of the District Court for the Northern District of Illinois would deny a motion to dismiss, but he dismissed the RICO claim because plaintiffs had failed to demonstrate the existence of a criminal enterprise apart from the racketeering activity, and RICO doesn't penalize parallel, uncoordinated fraud. The indirect purchasers reached a settlement prior to trial, and the direct purchasers lost at trial last October. Which brings us to the question, are RICO claims and private antitrust lawsuits a litigation Hail Mary with a low success rate? Joining me today as my co-host to help lead that discussion is Sam Randall, a shareholder in Chicago and Miami-based law firm Sperling, Nachtwalter. Welcome, Sam.
Thank you, Anant. Looking forward to this discussion today.
Sam, who do we have on the show today?
So I'm really excited about this discussion because we're bringing in two veterans of the broilers chickens case from the plaintiff's side, really the two architects of the plaintiff's RICO theory in this case, which I thought involved some really creative lawyering on their part. So we have Christina Lopez, who is currently a deputy attorney general in the California Department of Justice. Christina previously worked in private practice at Sherrard in Nashville. Christina also clerked on the Ninth Circuit for Judge Wynn. And we also have Ryan Holt, the other principal architect of plaintiff's RICO theory in this case. Ryan is a member and a partner of Sherrard in Nashville and is a truly talented lawyer who, both Ryan and Christina did some really creative lawyering here. And I'm excited to bring them in to talk about it.
Well, welcome, Christina and Ryan.
Thank you, Anant. And I do have to give the disclaimer that I'm sure is familiar to your listeners. Of course, nothing I say today has anything to do with my role at the California Attorney General's office. I'm here in my capacity as Ryan's former colleague and the work on the broiler chicken case.
And I'm glad to be here today as well. I'm excited about the conversation.
Sam, let me start off by asking you, how common is it to see RICO claims in an antitrust complaint, either brought by plaintiffs or by enforcers?
I'd say it's very uncommon. And, the only two cases I know that have done it are the LIBOR case and the broiler chickens case. And both of those cases started out as straight Sherman Act cartel cases. And the RICO claims were added later on to try to address some issues with proving an agreement between the defendants. That's the key question that I think we wanted to get into on this podcast, is that, broiler chickens and RICO both had this issue of proving an agreement as to a certain aspect of the claim. And so Ryan and Christina, we can start ladies first with Christina. What are the disadvantages and advantages that you walk through? Let's start with the advantages. What are the advantages of bringing a RICO claim in a competition case?
Sure, Sam. And you alluded to it just a moment ago. Of course, under a straight Clayton Act claim, you're looking at proving some sort of agreement, right? And agreement can mean various things under the Clayton Act and under the law. Well, under RICO, the sort of corollary to the agreement requirement is an enterprise. That's the term of art there. And you can prove an enterprise in various ways. The most common way in a case like this is called an association in fact enterprise. And that notion, that element of a RICO claim there's been a standard set forth by the Supreme Court in a case called Boyle. So what we were looking at in the broiler chickens case, and I imagine in LIBOR as well, was what are maybe the differences between proving an agreement under the Clayton Act and proving this association in fact enterprise under RICO? Because this hasn't been done many times, there's not so much case law on what the difference between those two things is, what the daylight is. But if you just read the standard that was set forth for an association in fact enterprise in the Boyle case that I referenced, you could see that proving an enterprise might be just a little bit easier than proving an agreement under the Clayton Act. The requirements are a little bit looser, at least in theory, like I said, and that's maybe something we'll get into today. But if you're just a lawyer reading those two elements, you might think, oh, an enterprise sounds like maybe a little bit less stringent than the agreement required by the Clayton Act.
Okay. So that's helpful. So Ryan, what was as you viewed it, what was the advantage to trying to prove an enterprise under RICO in the broiler chickens case, as opposed to an agreement under the Sherman Act and under the Clayton Act?
Yeah, so as Christina said, if you read Boyle and in cases applying Boyle, the standard for an enterprise, it just requires three things. So it's a common purpose is the first element, relationships among the defendants, and some sort of longevity to this enterprise. And so when you hear the word enterprise, for me at least, it connotes the idea of a business or something that may be more formal than an agreement or understanding under Section 1 of the Sherman Act. But then looking at the case law, you really just have to have people or organizations who are doing something, and you have to have that predicate act that Anant referred to earlier of a crime. And so that is a kind of a separate addition that's a disadvantage. But they have to be doing something in common, there are relationships among them, and they do it for a sustained period of time. That does not necessarily, in my view, require the same sort of conscious commitment to a common scheme that we are all rowing together and we know we're rowing together that courts often require for the agreement under Section 1. That reading the law, you can see it, as Christina said, as a different and arguably lower standard. The Supreme Court said in Boyle, the standard is, quote, obviously broad and, quote, has a wide reach. And so there's some statements in the law that suggest this should be an easy standard to satisfy. And then getting that accomplished in practice is what we're here to talk about today.
And so what was the enterprise that you two sought to prosecute in Broiler Chickens?
Yeah, so in Chicken's case, the enterprise that the plaintiffs alleged was the group of defendant chicken producers who were submitting prices to the Georgia Department of Agriculture that were being used to create the Georgia dock price. And so what we alleged was that by collectively submitting what we believed were false and inflated prices, that these defendants were acting with a common purpose, that there were relationships among them because there was a advisory committee for the Georgia dock that most of them sat on, and there were other relationships between them. And this took place for a period of many years. And so we claimed that it satisfied each of those three criteria that you need for an enterprise under Boyle.
And now, from a plaintiff's perspective, is there a difference in your recovery expectation under the Sherman Act versus a RICO claim? Were the damages that you were seeking to recover distinct in any way under RICO?
Not expressly under federal RICO. It's similarly to the antitrust claims, allows for treble damage recovery. It allows for prevailing plaintiff fee recovery. So those are similar things. We may get into here in a minute, many states have their own RICO acts that are patterned after the federal act, but some of those have separate requirements or lesser requirements as well. And so it's not just federal RICO that we looked to here. There is also a Georgia state, for our case, of course, with the conduct having occurred primarily in Georgia, we looked to Georgia RICO. And we found there that there may be the availability of punitive damage recovery. So, that's not present in the federal act. The federal act is much closer to the antitrust claims, but there are some states that have expanded RICO liability or damages as well.
And
that's a great point.
to allege RICO, was there a different underlying crime that you were alleging had been committed other than a violation of the antitrust laws? Was it wire fraud? What was the underlying crime?
Yeah, so the underlying crime that we alleged was, there were actually multiple of them, but the primary one was wire fraud. And it's important to note that you have to allege one of these underlying, are called predicate acts in the case law. Wire fraud is the primary one for doing that, as I understand it. But you don't have to prove that beyond a reasonable doubt. There doesn't have to have been a criminal prosecution. All you have to do is meet the civil standard and show that the elements of wire fraud would be met, which is essentially a false statement that someone relies upon that harms them, that crosses state lines. One quick addition to what Christina was saying on the damages for RICO, like the Sherman Act, you can get joint and several It is joint and several liability. And then also for direct purchasers who may have passed on some of the overcharge and the harm to their customers, there is case law, at least in the Seventh Circuit, and I believe in other circuits as well, that you don't offset those damages, that the direct purchaser recovers the full amount of the overcharge as their damages. So it has all the benefits of a Sherman Act's Section 1 recovery.
Yeah, I think that's a really key point because, as you describe it, RICO sounds like a more complicated version of just a common law fraud claim. Now, why would a common law fraud claim have been viable here or worthwhile for your clients in this case?
So the challenges with common law fraud, the big one is if you're representing direct purchasers who may have passed on some of the overcharge to their customers down the supply chain, then typically, as I understand in common law fraud, it's you recover what your actual harm is, not the standard of recovering all the overcharge. And so that's a big problem for it. And also there's sort of the federal versus state jurisdiction. The federal RICO obviously keeps you in federal court. That fraud claims, you'd have to have that federal claim to go along with.
And one other thing we thought about with the common law claims, at least if I recall, Ryan, was, then you're getting into choice of law questions, you're getting into various state law requirements that might differ among the states, and you might just have a different sort of procedural fight on your hands where, with the federal RICO, at least, it's a standard that applies to everyone. And as Ryan said, it's got the same benefits as a Sherman Act claim as far as damages go. So to your point, Sam, while it does present as a slightly more complicated version of fraud, it does have some benefits if you think there has been fraud.
From a plaintiff's perspective, are there also discovery advantages to not having to prove a lost profits claim?
Yeah, I would say certainly on that. It's going to be different economic modeling and presumably easier to prove that than to show what lost profits are, and then what that opens your clients up to in discovery for what part of the harm they may have passed on to their customers.
Right. Because I would think with a lost profits claim for a retailer, you'd be opening yourself up into discovery for, not only your chicken business, but also all of your proteins and then, your downstream business, what's your pass on? How do you adjust your costs in response to price increases and all of that? I mean, for a common law fraud claim, that would all be fair game, I would imagine, right?
I think so.
This was all very creative lawyering, but we have to sort of get to the other side of this. How in broiler chickens, how did these claims fare once you got to summary judgment?
Well, can I start by saying how we did on the motion to dismiss?
Absolutely. So let's Christina, how did these claims fare in the motion to dismiss? Let's start there.
Well, they survived the motion to dismiss stage. We actually got some really nice language from Judge Durkin at the motion to dismiss stage about how these claims on the Georgia Dock index were stronger in his view than some of the broader antitrust claims relating to supply cuts and other things that had been alleged. He easily found that the pleading satisfied these enterprise requirements that we're talking about, along with the other conduct, the predicate acts of wire fraud and those things. It was a nice, tight little opinion and survived at that point anyway. And then, of course, we do have to talk about summary judgment.
And did Judge Durkin draw comparisons between what was happening with the Georgia Dock and the LIBOR case?
I don't recall any comparisons to LIBOR. In fact, I don't even recall much citation to Boyle, this case we're talking about for the enterprise. And, Judge Durkin didn't say anything about the difference between an agreement and an enterprise, this notion that we're talking about. He really limited it to a pretty straightforward analysis of the elements of RICO and whether those were in the complaint for this specific Georgia Dock conduct. As Anant mentioned at the top, there the opinions in LIBOR existed at the time. It wasn't that he didn't have access to that, but he really kind of, I think, took the pleading on its face, as you might expect at a motion to dismiss stage.
And then the flip side of this, Ryan, what happened on summary judgment?
Well, summary judgment, as I think you may recall, Sam, so there were hundreds, if not over 1,000 pages of briefing on all the different claims and issues in the case with the multiple classes and all the opt-out direct purchasers. A couple of full days of oral argument were broken into a bunch of different motions. And one of them was the Georgia doc as a whole. So that was the defendants moved for summary judgment that both the Section 1 Sherman Act claim of a conspiracy to manipulate the Georgia doc and also the RICO claim to manipulate the Georgia doc, that summary judgment should be granted on that. And ultimately, Judge Durkin ended up granting the defendant summary judgment on all aspects of the Georgia doc, both the Section 1 and the RICO claims. And in his 91-page summary judgment opinion, it's toward the back, and there's just a few pages on the Georgia doc, which at that point in the case really had not been the focus of a lot of the discussion and the evidence in class certification and summary judgment, which was more centered on the supply restriction conduct by the defendants. And so what Judge Durkin ended up doing was saying he didn't think there was sufficient evidence of a conspiracy amongst the defendants because there was not enough evidence to show that they all agreed and knew that they were submitting false and inflated prices to survive summary judgment on Sherman Act, and then essentially found the same thing for RICO. And cited a Seventh Circuit case saying that uncoordinated fraud is not covered by RICO, but that was really the extent of his analysis and the citations to the case law on RICO, and not as much kind of delving into what we discussed earlier on how an enterprise, according to Boyle with the Supreme Court and some other case law, may be something different than a conspiracy under Section 1.
And now, Christina, what happened to the Georgia RICO claim to summary judgment?
It wasn't discussed at all. And so we haven't talked much about the Georgia RICO claim here, but one of the benefits we found under Georgia RICO, after having surveyed various state RICO acts that might apply, was that Georgia is one of the few, if not the only states, to not even require an enterprise for part of its RICO claim. And so we've talked a lot today about what an enterprise means. Georgia RICO, you didn't even have to do that. You just had to have, a couple instances of a predicate act, which under Georgia RICO could also be fraud, and kind of run with it from there. And at the motion to dismiss stage, the defendants had not even moved to dismiss that claim because they acknowledged it didn't require an enterprise, and that was the basis for their motion. Well, come summary judgment, I think, as Ryan said, there was a lot going on in the case. It hadn't really been the focus, and it wasn't addressed separately in the order. I mean, all the RICO claims were dismissed, right? I mean, summary judgment was granted, but it was not separately analyzed.
And so, we're getting into maybe some inside baseball here, which is not helpful for distinguishing the opinion. But I view Judge Durkin's opinion as essentially a trial management order, that he was faced with, almost 20 defendants in a trial that had to go forward. And he acknowledged that if the supply restraint allegations were tried alongside the Georgia RICO allegations, that the trial would take, 4, 5, 6 months. And just be almost, recognizing that it would be very difficult to try. I mean, is that a fair assessment of that ruling?
I would only add to that. I don't know what was going through Judge Durkin's mind, but in his opinion, he did say that if he had allowed the Georgia doc claims through, that he would have severed them for a separate trial. And it wasn't just one trial. There were, at that point, 4 separate tracks to the case, and are today 3 separate tracks, which, and ultimately some parties ended up settling and then narrowed the case somewhat, but the prospect of having 4 trials over a period of however many years, each of which could be 2 to 3 or 4 months, and then adding on top of that the Georgia doc as another set of 4 trials. If I were a judge, I would not be excited about doubling the number of trials that I'd have over a 2 to 4 year period.
And I think that's important, Sam, because that's how these antitrust cases go as a general matter, right? It's not just inside baseball here. They often are large case management type cases. And, other plaintiffs may be in a similar situation where they're facing distinct sets of conduct. If it's one set of conduct and you're bringing a Sherman Act and a RICO claim, you might not encounter that same hurdle. But where there are these various allegations of misconduct that are a little bit distinct and the proof will look different for a RICO claim, I think that is just a reality of case management for a judge that's staring down that number of trials, like Ryan said.
Yeah, that's right. And so the Georgia, even though the Georgia RICO claim wasn't dismissed, it was not included as part of the trial against Sanderson Farms, right?
That's right.
Yeah.
Whether it was dismissed or not, I think to Christina's point, I think the order probably should be read as granting summary judgment on that claim, even if there wasn't analysis of it, but that was not a part of the trial.
So any plaintiffs are looking for precedent from there, go to, look at how the Georgia RICO claim fared.
What I would add just on the value of these claims generally, because I think there are a lot of lessons to be drawn for litigators on the use of RICO in these types of cases. But the end of the story of having the RICO claim dismissed on summary judgment doesn't tell the whole story of the value that it may have added to the plaintiff's cases over the course of 3 or 4 years of litigation leading up to that point.
Right.
So I do believe that there is value in one, differentiating yourself from other plaintiffs in a large group, such as these big MDLs or consolidated cases can be, and in kind of staking out a different area of law where, depending how the case law develops on RICO versus the Sherman Act for cases that can last, 5 to 10 years with appeals, depending on how your judge may receive that, how different twists and turns in these big complex cases play out, I do believe that there is value in staking out those alternative claims.
And so in broilers and broiler chickens, Judge Durkin granted summary judgment on the federal RICO claim based on the enterprise issue. In LIBOR, there were a number. The Second Circuit really did a hatchet job on the entire case. But as to the fraud claims and the RICO claims, the Second Circuit ultimately overturned the criminal wire fraud convictions that formed the predicate acts for these RICO claims, saying that essentially because LIBOR involved some subjective elements that, suppressing the LIBOR submissions couldn't form the basis for a criminal wire fraud conviction. So, under the umbrella of all of this case law, is there a future for a RICO claim, in an instance where you have an index that's been apparently manipulated by a supplier?
Yeah, I think that is one interesting difference, at least in my view, between LIBOR and broiler chickens, is Judge Durkin didn't really question the predicate acts of fraud. And maybe it's because those weren't really how the defendants were attacking the RICO claim, but he was really focused on the enterprise element, whereas in LIBOR, you do see more discussion of what it means to commit fraud on an index. And of course, that's something that has to be taken into account. But I view LIBOR as pretty fact specific in that way. I think it does matter what the index is meant to do. And that was true in our case too. What was the Georgia doc price that a defendant was submitting supposed to be? Because of course, that's how you determine whether someone commits fraud, right? What were they supposed to say? And in that way, I do think LIBOR is a little bit distinct. Now, that rationale may apply to many indexes. I don't know, indices. It probably just depends on what people are supposed to be doing. And maybe that's a way for defendants to shore up their own conduct in these types of cases, is to, define the conduct in their own way. But the fraud holdings in LIBOR, I do think, are pretty fact specific and don't necessarily preclude these sorts of cases going forward. One of the interesting parts of LIBOR, I think, the RICO claims, it failed there for a different reason in terms of securities being sort of an exception to a RICO claim. But even in the civil case, the court did comment about being skeptical of the enterprise. And so I think that maybe while the fraud discussion is more specific to LIBOR, developing law on what an enterprise is probably going to be the harder push, and finding a judge that could maybe not create law, but just have a different take on, as we say, the daylight there between the claims, and not really lump them together.
Right, because and that I think is sort of the central issue. Ryan, do you think that there is, if Judge Durkin's ruling is the law on this going forward, is there space for a RICO claim separate and distinct from the Sherman Act claim? Or you essentially need an agreement under RICO, and so it's become, what's the point of a RICO claim?
Yeah, if Judge Durkin's summary judgment ruling were the law, then I don't think there would be any added value to a RICO claim, because as I read his summary judgment opinion, he essentially applied the same test for an agreement under Section 1 and for an enterprise under RICO. There's certainly a lot of law that can be read to suggest a different standard than that. And I wonder, to Christina's point, in addition to the case management aspects of what was happening in chickens, just with the number of plaintiffs and defendants and looming trials, and how the focus of the case was on the supply restrictions and not the Georgia dock for the most part. In addition to that, where Anant started up top, that RICO began as an anti-organized crime law. The R in RICO is racketeering. And even if it has been successfully used in a lot of instances for white-collar crime and misconduct, similar to what we allege with the Georgia dock, that there's still this nature of seeing RICO and an enterprise as being something more than what the Supreme Court, to me at least, says in Boyle that an enterprise is, and requiring a kind of a higher burden of proof, or at least an equal burden of proof, for showing an enterprise as to showing an agreement. And maybe part of that comes from just this idea of RICO as being, requiring some heavy showing that would be needed for organized crime.
And I think that's an important point, right? Is that, when you're thinking about bringing a RICO claim, you have to get over the hump that there's going to be sort of some inherent skepticism, maybe, that, you're suing Tyson and Pilgrims here, and they're these white collar employees or farmers for, violations that, when you think of it, you're sort of thinking about Tony Soprano or The Godfather. That, you have to come up with facts, or you have to have facts that can get you over that inherent skepticism that you might get from the court, right?
Yeah, I agree with that 100%.
So, assuming that you have a court that would, more closely follow Boyle than Judge Durkin did here. If you're in-house counsel, does RICO impose any additional obligations from a competition perspective that beyond what the Sherman Act imposes? Beyond sort of the obvious, don't commit fraud, but these, in LIBOR and broiler chickens, conduct that was very clearly suspicious in both of these instances the defendants have largely been able to skate on that conduct, right? I mean, so is that a cynical takeaway that RICO doesn't impose any obligations on these companies beyond what the Sherman Act does?
I'm curious to hear what Ryan thinks on that. I think because of the nature of RICO that Ryan was just talking about, it isn't really focused at competition. It is focused at criminal conduct. And so I think if you're in-house counsel and you say, don't commit crimes, you're getting pretty close to your RICO obligations. I think, it doesn't really apply in every run-of-the-mill antitrust matter because it does require these underlying predicate crimes, which I imagine would most often be the fraud ones, as opposed to some of the other predicate acts that are listed. But yeah, I think if you're doing your job as a general counsel and advising on Sherman Act and then separately on criminality, you're probably covered.
Yeah, I agree. The nuance I would add is that if your business participates in submitting information to some sort of index or aggregator or algorithm, that you pay careful attention to what is the question that we are answering. I think that's the key takeaway from the Second Circuit's opinion, and then something that what I believe was important in the chickens case as well. If you're being asked a question that is calling for specific information that can be shown to be true or false, something you have data on. In the chickens case, it was, what is your offering price for a 2.5 to 3 pound bird? And there were some complexities that came out of that, but many of these companies sold that bird. They offered to sell it at a certain price. If they submit a price that's different than that, then you're allowing plaintiff's counsel to say, you're submitting false information. You knew you were doing it because you had your own data and you were doing it across interstate lines. In LIBOR, the question was more of a hypothetical one, like what might you be able to borrow at? And the Second Circuit therefore said, well, even if they weren't actually borrowing it, that they may have been able to borrow that. And so, you can't prove it that they knew it was false or that it was false. So I think the key is you look to the question. If it's a question that somebody could later prove that your information is false, then maybe it would be smart to have a practice of, well, one, advising the people who are submitting that information, we need to make sure that what we say lines up with our records and with the truth, and then periodically auditing it to get a sense of, are we submitting accurate information? Because if it's calling for something that can be proven false and you're submitting false information, there may be enterprising plaintiffs' counsel out there later if the index goes haywire or other issues come up in discovery and lawsuit where you got a problem.
And now, so, I going way back to the eggs case. I remember Ernerberry is an index. It's not just an eggs. It's used with a number of commodity proteins. Remember in a deposition, a veteran of the egg industry, when asked to explain what the Ernerberry was, he said, you have the people who run this index. They call up, a couple big egg companies and say, what price are you getting for a dozen eggs? And, each of these companies lies by a couple cents, and they write that down. And they call up a couple large retailers and say, what price are you paying for, per dozen eggs? And each of these retailers lies by a couple cents, and they write that all down, and they come up with an index. I mean, so is there, and that's in some ways that's business as usual. When you're in negotiations with someone, you should kind of expect someone to fudge a little bit on the prices they're getting or what the market is doing. Is that a realistic standard that for people to follow?
I mean, I would say I see this as different than negotiating. If you're submitting information to a benchmarking service, price index, or an algorithm that's going to be providing proposed prices for you and your competitors and your customers, then that to me is different than saying I would be willing to pay this to buy this from you, or I'd be willing to sell this product to you at this price. We have just people are used to negotiating in that context, and they know that may not actually be your best and final number. But when you're submitting that information to a benchmarking service or an index, I believe there's an expectation that that information is going to be accurate. And then it goes back to what's the question that's asked. If the question is asking for something that's concrete and you're representing that that's your true information, and you don't include accurate information, I think that does open you up at least to the risk of RICO claims. And I think as a public policy matter, you can see why. I can make an argument for why it should, because if people are relying on the information that comes out of that as being accurate and something more than just posturing, then we should be able to expect that people are putting good data into it.
And that's what I was going to say, Ryan. I think a lot of the issues here do turn on what the public is expecting, right? I mean, that's true across the board. And so if the public is aware that the Ernerberry is calling up the sellers and the buyers, then you can expect those things to wash out a little bit. That's going to be a different circumstance than what we had in Georgia Doc, where they were only calling the producers and the public didn't know that, right? And so again, to your question of what you can do to advise your in-house clients, some of it is really just transparency in protecting yourself from the down the road claims of, well, if everyone knew that this is how the index worked, that might be a different circumstance than something that's happening behind closed doors. And then people are relying on information that they don't have the full picture for.
And Sam, you also raise what would be best practices for benchmarking. Because if I recall correctly, Georgia Doc just surveyed one side of the transaction, the chicken producer side. So you have greater potential for skewing the results.
Yeah, absolutely. And I mean, I think that should be one of the takeaways here, particularly, for, Georgia Doc was run by a government agency. It was run by state, by the division of the state of Georgia. And so, but all of these indices are trying to create transparency for pricing that the public can rely on. And I think one of the takeaways from these cases is that it's really important to remove any arguable subjectivity in the submissions. That, to the extent that you can base the index on something that's verifiable, so that you remove the incentive for people, or remove the ability for people to fudge it by a few cents in any direction. It makes these indices much more effective at providing transparency on what the market price is. And so, one of the future applications of this that I think is going to come up more and more is that you have AI-driven algorithms that are providing pricing recommendations, or essentially taking the role of pricing indices in a wide range of industries. What, does RICO have a role in policing that? What are the takeaways? What are the applications of RICO in some of the cases that might come up over the next 10 years as AI and algorithmic pricing becomes more and more prevalent?
Yeah, Sam, I think that's right. That probably is the next frontier. You've already seen a couple cases like that percolating, and they don't have RICO claims, to my knowledge. One of the hurdles, and I think we talked about it today, is, if the most common predicate crime that we're talking about with RICO in these contexts is fraud, what is fraud in those circumstances? If I've entered into a contract with an algorithm to set my pricing, what information have I given them? And is that information accurate? It goes back to what Ryan was saying earlier about paying attention to the question. And so one hurdle, I think, potentially in using RICO in those contexts is just technology based. And it's, what does fraud look like there? The enterprise question might be a little bit different. If everybody has entered into the same contract with the same algorithm and everybody knows that, then maybe you're back to the same sort of analysis that we've been talking about already with these other indices. So of course it's all going to be fact specific, but AI in particular might have its own set of obstacles, I think.
Yeah, and I would add that I think that the importance of RICO in these cases, in the algorithmic price recommendation setting cases, that the importance of RICO may turn on how readily courts find agreements under Section 1 of the Sherman Act in those cases. Because if courts are finding that if a group of competitors all share data with a company that puts it into an AI algorithm and then sends back prices that they all use, if that is a violation of the Sherman Act, then you don't need RICO. RICO's not really adding anything. RICO potentially adds value, and so if courts find that fact pattern, which we have a lot of early stage litigation right now involving algorithmic price setting, doesn't qualify as an agreement, then I think the RICO claims could potentially add some value there from a plaintiff's side and create risk for the defense companies that are sued. And again, it goes back to are you providing the information that you're being asked to provide? And if you're not, and especially if there's any indication that you knew that you were not, or that you were excited that the information that you were providing may be beneficial to you in your prices with customers, then that could pose a RICO risk for you.
Ryan, Christina, Sam, this has been just a fascinating discussion of the use of RICO in this private antitrust litigation. When I was reading the Georgia and Southern District cases last night, I was left with the thought that maybe benchmark cases are a higher burden, a higher bar in which to bring RICO cases, because in neither of those cases was the benchmark itself the enterprise. The benchmarking itself was not the illegal activity. I mean, if the benchmarking was the illegal agreement, boom, you have your Sherman 1 case, harm is presumed, everyone goes home, works on their damages estimate. But if the central agreement is itself not illegal, then you have to prove an enterprise on top of it. So, bringing RICO claims is hard. We'd love to go around and just get some takeaways here for practitioners. Ryan, let's start with you.
Yeah, I think that the key takeaway for me is that if a company is being asked to submit information that's going to be used for future prices, that they should pay attention to the question asked and accurately respond with information.
Christina.
Yeah, I think there's a couple. One that we've talked about quite a bit here is, what's the daylight between the agreement and the enterprise? And so I think the takeaway there is, if you've got a Sherman 1 case, like you said, just do that. But maybe on the outer edges, when it's not so clear cut, RICO adds some value. The second one I would say is take a look at those state RICO acts. There's some gems in there sometimes. Some of them are the same as the federal one, but sometimes they're not. And there may be added value there in the various state versions.
Yeah. And then, Ryan and Christina have taken mine. So I'll add that, if you're a large retailer, or, and you're looking to protect yourself from a competition perspective, both to make sure you're getting a fair price, but also to protect any competition claims you have. I think it's really important to push back when you're using indices to make sure you know exactly what that index does. And that, with the Georgia doc, it was subject to exploitation here. And so you had these companies that were stuck with these pricing formulas in their contracts that were tied to the Georgia doc. And so, for sophisticated companies that, are really able to push back on the use of these indices, make sure you understand what you're buying and how that formula is going to how it's going to be calculated, and it's not subject to exploitation.
Well, thank you, Sam, Christina, and Ryan, for this fascinating discussion. There was a lot of good information in here for practitioners. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.